thank you very much for joining us this morning. Very pleased to see so many of you are interested in this topic. No surprise, really. Some significant changes coming to the immigration rules governing the child student visa. So good to see that you're all aware that those are happening and want to find out more. So thank you very much for tuning in this morning. Quick overview of what we're going to be talking about this morning. I'm going to start by looking at the current rules and spend quite a bit of time on that just to make sure that everybody's comfortable with how the rules currently operate. And then we can compare and contrast and look at what's changing from the introduction of these new rules, which is on the 29th of May, so not too long at all now. In talking about those new rules, I'm going to look at the concepts of educational guardians, as they are a pretty significant change, new requirements as far as the new rules are concerned. I'm afraid that we have lots of concerns about how the new rules are supposed to work in practice. And for those of you who I've spoken to over the last few weeks or exchanged emails with, I may have promised you hopefully some further clarity on these new rules, having asked and pointed out lots of problems with the new rules to contacts at UKVI. Unfortunately, I have not had any concrete responses to those questions. And so I will be going through some practical suggestions on how to navigate the new rules based on what they currently say, but that will all be issued with a very heavy caveat that at some point within the next couple of weeks, we might get further clarity from the Home Office. And so some of these practical solutions, while I expect them to still apply, may not be quite as draconian as it might first appear. There's also to be introduced a new sponsorship duty in relation to collecting details of travel arrangements. We will talk about that at the end, but the majority of what I want to focus on are these new rules governing care arrangements as are coming into force from the 29th of May. So to give you a bit of a history and to talk about what the rules currently say, it's worth sort of noting that the way that these rules around care arrangements for child student visas have been introduced has been fairly piecemeal over the years. And for those of us who are, the immigration lawyers and sort of live and die by what is actually contained within the immigration rules themselves, trying to interpret what care arrangements were required for someone coming to the UK to study at an independent school was a little tricky, because the way those care arrangements requirements were imposed was through the financial requirements. So the financial requirements would say this is how much money the child student needs to have available, and this is how you calculate that based on their care arrangement. There wasn't actually any explicit reference to these are the permitted care arrangements for a student coming to attend a day school or a boarding school. There was just this sort of implied requirement, as I say, imposed through financial requirements, and similarly through the sort of mandatory documents that had to be submitted in support of those. But essentially, what that sort of very sort of bizarre way of framing the requirements did was said that there were 5 approved care arrangements / living arrangements for someone coming to the UK on what used to be known as a Tier 4 child visa, and since 2020 has been referred to as a child student visa. So these 5 categories. Boarding is one, all boarding students lumped in together, be they full, weekly, flexi boarding. A boarder is a boarder is a boarder. And then 4 permitted living arrangements for day pupils. I'll go through each of them in turn, and it may seem a bit laborious to do so, particularly those of you who are very familiar with those, but there are some important definitions within those rules which will apply as far as the new rules are concerned. So the 4 approved arrangements for Day pupils, first is to be living with a parent who holds a, as I've said on the slide, simply for the purposes of space, but which I'm not going to use, this POAX visa, the parent of a child student visa. So parent holds a particular type of visa, the child can live with them. A day pupil can live with a close relative, but that's defined, and we'll come on to what those definitions entail. They can live with a private foster carer, or if the child is over the age of 16, they are permitted to live independently, albeit they must have their parents' permission to do so. Again, we'll talk a bit about that in due course. In addition to what the immigration rules say, we've also got our Bible for compliance as far as student visas are concerned, and that's the student sponsor guidance, and in particular, document 2, which looks at our sponsorship duties. And within document 2 of the student sponsor guidance, there are various references to care arrangements which apply to students under the age of 18, child student visa holders. So some important points to sort of flesh out from that. Where you sponsor a child under a child student visa, a child under the age of 18, you must ensure that there are suitable care arrangements in place for them, and those care arrangements would cover their travel, their reception on arrival, but also their care, or their living arrangements while they're in the UK. So this idea of suitability is something that you are ensuring suitability, something that you're responsible for. There's a sometimes overlooked record keeping duty to ensure that you have the consent of the parents for the care arrangements, the travel reception care arrangements for the children that you sponsor. And then relatively recently, we had introduced some additional, what the guidance refers to as specific child student safeguarding duties. And these rules were introduced, as I've just sort of flashed up on the slide, following reports of child student visas being used to sort of traffic children into the UK, and then those students not turning up with their schools. And so, while in those particular cases at that time, this was back in 2019, UKVI were at pains to say that they couldn't find anything, any breaches in the compliance as far as the particular schools that were targeted in those cases were concerned. They did then introduce these additional requirements to the rules, which require schools to ensure that they have policies in place relating to safety, well-being, and protection from exploitation of the children which it sponsors. And then also introduce a couple of other points as well, but significantly for our purposes, a requirement to ensure that a child student's living arrangements meet the requirements of the route. And the way that's been interpreted is to say that you need to ensure that while the child is in the UK and on a child student visa, their living arrangements always have to meet the requirements of the route. So these 5 categories that we're talking about, these 5 categories of approved or permitted living / care arrangements need to be in place throughout the time that the child is in the UK and on a child student visa. So taking each of these sort of current requirements in turn, what do the rules and the sponsor guidance say say in relation to borders? Well, actually, not very much. Really, quite simply, that the care and accommodation requirements have to comply with the national minimum standards for boarding, as you might expect. So those contained within national minimum standards themselves, and relatedly the independent schools standards regulations. That's pretty much it. If you're complying with those, then as far as UKVI are concerned, then the care arrangements you put in place for borders are suitable potentially. Moving then on to the arrangements for day pupils, and it's worth flagging at this stage, and I'll continue to do so as we go along. All of these changes that are being introduced from the 29th of May, on their face, well, they do really only apply to boarders. Day pupils aren't really affected by these changes. But the reason why I'm going to talk for the next few minutes, the next few slides, about the current living arrangements for day pupils is, as I mentioned earlier, these definitions will flow into these new rules that are being introduced from the 29th of May. So the first of the categories which I referred to, the POAX visa, as nobody calls it, the parent of a child student visa. So a parent gets this visa, and then they can be the prescribed carer for their child in the UK. That visa, parent of a child student visa, is only available to one of the children's parents, and it's only available while they have a child attending an independent school in the UK on a child student visa, who is under the age of 12. So if we're talking about, your pupil, they can attend as a day pupil with their parents caring for them, really up until the age of 12 only, because that's the point at which the accompanying parents' visa will expire. If that pupil has younger siblings who are also attending independent schools as day pupils, then the parent's visa can sort of be can be extended on the basis of those younger siblings. So a child over the age of 12 could continue to live with that parent. But once all of the children within the family have reached the age of 12, then that visa will no longer be available to the parents, and so alternative care arrangements would need to be found. They wouldn't be able to live with that parent any longer. Next permitted care arrangement is to live with a close relative, but close relative is very tightly defined. First of all, it needs to be someone over the age of 18. And then the type of relationship with the child is also set out within the immigration rules. So it's a grandparent, step-parent, brother or sister, and then a blood uncle or a blood aunt. So it couldn't be an uncle by marriage, couldn't be an aunt who's just a close family friend with children known all of their life. Also doesn't include parent, you will note. Step-parent, yes. Actual parent, no. Significantly, that close relative needs to be either British or settled. It couldn't be a relative who's in the UK on, for example, a work visa. It needs to be someone who has a permanent right of residence here, either having been granted indefinite leave to remain or be a British citizen. So that's what the rules say as far as living with a close relative is concerned. Remember, though, and I'm probably going to mention this a few times, the school still has a duty to ensure that the living arrangements are suitable. And so if your pupil happens to have an 18-year-old sibling who's in the UK attending university, and by some accident of birth or other quirk, that older sibling is British, but your pupil is not, would you consider living with that close relative, that older sibling, to be suitable? Almost certainly not if they're living in halls of residence with dozens of other students. So, but anyway, I'm sort of taking that to a particular extreme, but certainly it's something you need to be considering as part of your sponsorship duties. Also worth introducing at this stage the concept of a letter of undertaking. So where a day pupil under the current rules is being cared for by a close relative, that close relative needs to write and sign a letter of undertaking with various prescribed bits of information set out in the immigration rules to confirm that they're taking on responsibility for the care of your pupil. And that letter of undertaking needs to be submitted with the visa application. So there's a best practice point there is to make sure you have that letter of undertaking. You've seen that letter of undertaking so that you, before you assign the CAS, so that you know that it's available to be submitted with the child student visa application. Next, prescribed living arrangement is to be living with a private foster carer. This is another one just to really focus on for the purpose of these incoming changes. So private foster care is a defined concept. It's not something dreamt up by the immigration rules. That does happen from time to time. The Home Office introduce some concept they think is defined elsewhere or well understood, but actually it has no legal definition elsewhere. But in this case, private foster care does. It's defined within sort of various bits of regulation, but ultimately it's something which is created by the Children Act and various bits of enabling regulations under that. Private foster care arrangements only apply to children under the age of 18. Under the age of 16. A private foster carer cannot be a close relative. That's why we have two different prescribed living arrangements. One is living with a close relative, in which case private foster care does not apply, cannot apply, and living with a private foster carer. So an adult who is not a close relative would need to be a private foster carer. Under the regulations, private foster care only arises where the intention is that an adult who is not a close relative will be looking after a child for 28 days or more. There's statutory guidance which has been published and has been around for quite a number of years, which provides lots of guidance about how the private foster care regulations are to be interpreted and applied, principally by local authorities. And that guidance makes it quite clear that the 28 days is meant to be a continuous period. That 28 days might be broken by short breaks, so a sort of weekend with another family member or another relative or another appropriate adult, but generally over that 28-day period, the intention is that it would be continuous, not made up of, lots of sort of shorter periods. So bring it into a boarding context. A weekly boarder who is staying with an adult who's not a close relative every weekend, under our interpretation of the private foster care regulations and the underpinning and the statutory guidance, our view is that the private foster care arrangement is not arising in those circumstances because it's not there's no continuous 28-day period of care. Where private foster care is proposed, then the local authority has to be notified. The local authority is under a duty to visit the premises and take other steps to ensure the suitability of the care arrangements. For purpose of the visa application, so where this is proposed before a child comes to the UK, where it's declared that the child will be living with a private foster carer, confirmation of the local authority's approval needs to be submitted with the visa application, along with final bullet point on the side, a letter of undertaking from that private foster carer confirming in a similar way to the letter of undertaking that a close relative would need to provide, that they're prepared to look after the child and be responsible for them throughout the time that they are in their care. So you need these two documents, the letter of undertaking and the confirmation of local authority approval when the visa application is submitted. Also worth flagging, I'm sure that your safeguarding leads will be aware of this. Schools are under a duty to notify local authorities where they become aware of a private foster care arrangement arising. And final point to raise, if there weren't enough hurdles to jump through, the private foster carer needs to be either British or settled as well in order for it to be an approved care arrangement under the immigration rules. It is possible for a 16 or 17-year-old to live independently in the UK. That's sort of recognised within the immigration rules, within the sponsor guidance. I've quoted on the slide what the student sponsor guidance says about that. So students aged 16 or 17 have the legal right to live independently and may make their own accommodation arrangements, but they need to have their permission both to travel to the UK and to live in the UK. They need to have the permission of their parents. In practice, are any of you going to be comfortable with a student living independently, living on their own? Almost certainly not. It probably, in most cases, would fail that suitability requirement in any event. So where we tend to use this sort of living independently category is where the child isn't suitable for the child to live in boarding, for example, and instead we make arrangements for them, or the family make arrangements for them to live with somebody else, maybe a parent visiting the UK for a few months, just to sort of get them back on their feet as far as boarding is concerned, or maybe to live with a family friend who doesn't meet the close relative definition, or maybe is on a sort of longer term but nevertheless temporary visa. So that's where we tend to see these living independently arrangements come into play, not in situations where the child is genuinely living on their own, creating a god-awful mess, as the picture on the slide suggests. I think I've spotted a few questions have come in. Let me just quickly deal with those before I move on, although it might be that some of those I'm going to address as we come along. Okay, so I've had one question as to the meaning of settled in the context of foster care. That's a good question, thank you. Settled means somebody who has indefinite leave to remain, so has been granted indefinite leave to remain. That could be under the EU settlement scheme, but there's a difference under the EU settlement scheme between pre-settled and settled, and for the purposes of childcare arrangements, settled means they need to have been granted settled status rather than pre-settled status, or it might be that they've been granted indefinite leave to remain under another immigration category. So maybe they've been here on a work visa for 5 years. They would be granted settlement or indefinite leave to remain, as it's sometimes otherwise known, referred to. So that's what we mean by settled in this context. A couple of other questions. Some I'm going to skip over just for the time being, because I think I'll deal with those a bit later. Yeah, okay, fine. I'm going to pick up those questions as we go along. They sort of, I'm definitely addressing those later on. So, what else do the current rules say and guidance say in relation to care arrangements? Well, you can do a search of the current versions of the student sponsor guidance for the phrase educational guardian, and you will find nothing. There is no reference to educational guardians under the current version of the guidance, and yet reports we have back from schools who've been visited are that there is always a lot of questions about educational guardians from compliance officers, and so it would seem that certainly a lot of schools are being asked about educational guardians, and I think UKVI, under the current framing of the rules and the guidance, would see that as best practice, where there's no one else in the UK able to care for the child. Compliance officers will also ask boarding schools about arrangements for collection from school, monitoring of whereabouts and so on. But really important to note, and I get lots of questions that have been asked of schools, you know, oh, should we be doing this? Should we be doing that? There's very little in terms of a consistent approach, and quite often my responses to those questions come back to, well, what does the guidance say? What do the rules say? And actually, they don't say very much about these things. So generally speaking, concerns around safeguarding were raised by compliance officers come under these sort of these headings, as I've sort of suggested on the slide. So general concerns around care arrangements not being suitable. So the school hasn't done enough sort of due diligence on a care arrangement that's been proposed for a child, either in relation to a day pupil or in relation to a boardroom and the care arrangements that are in place for them, either in holidays, exeats, and so on. A failure to apply the specific child safeguarding duties that I said were introduced following the stories of those children being trafficked into the UK back in 2019. So in particular, failure to ensure that care arrangements continue to comply with the requirements of the immigration rules where they've changed after the child has arrived in the UK. And then we also have, I mean, certainly in relation to the requirements to monitor whereabouts, arrangements for collections from school and so on, they tend to be enforced primarily as a record-keeping duty. So in accordance with Appendix D of the sponsor guidance. So, and in particular, this final point, which requires you to maintain a history of the migrants' contact details. That's where UKVI say that you need to be monitoring and keeping records of whereabouts for the children that you sponsor during the periods that they're not in the care of the school. So, what are the new arrangements? What do the new rules say? So, as I've said, mentioned this date many occasions already, 29th of May. Care arrangements. We've got sort of various bits coming into force. First thing is that a new care requirement is being introduced, and there the rules say that the decision maker needs to be satisfied that there are appropriate care, living, and guardianship arrangements for the child's safety while they're in the UK. So, in other words, if a visa officer is not satisfied that there are appropriate care arrangements in place, if they will make an assessment as to whether those care arrangements are suitable. If they don't think that they are, the visa application will be refused. There are also requirements as to the suitability of the nominated carers. If the person who's nominated as the carer for the child on their visa application has received a prison sentence of more than 12 months, then the application must be refused. Note that word must. It must also be refused if the carer is a persistent offender or if they've committed an offence which has caused serious harm. And indeed, if anyone else living with them has committed an offence of that severity, the application has to be refused. So it's not just the person named as the carer, it is also who else lives with that person, and is there any grounds to believe that they might not be suitable. Applications may be refused where a guardian or a carer or anyone else living with them has received any other criminal conviction. So these are all things which are sort of being brought into the visa application process as part of the consideration process, and in some cases must lead to the refusal of the application if there are concerns as to the carer's criminal background, and in some cases may be refused. So certainly something that we need to be asking questions about at the very least. And I will come on to sort of how we address this practically in a few slides' time. In addition to that care requirement, there is also a living arrangement requirement. So the rules will now, from the 29th of May, explicitly set out what the living arrangements have to be for child student visa holders. Unlike the current situation, where, as I mentioned right at the beginning, it's sort of obliquely referred to as part of the financial requirements. The living arrangement requirement distinguishes for the very first time between full, weekly, and flexi boarding. We don't have a definition of the difference between weekly and flexi boarding. I don't know how many nights a week weekly and flexi boarding is. That said, it doesn't really matter because as far as the rules are concerned, they treat both weekly and flexi boarders the same. There's a slight difference as far as full boarders are concerned, as we'll see in a moment. But yeah, so we've got this distinction between weekly, flexi, and full boarders. In each of those cases, for each boarder, we need to identify a carer for the child for the periods when they're not in the school's care. For a full boarder, that can be somebody which the rules refer to as a nominated guardian, but I think for our purposes, we would refer to as an educational guardian. It seems quite clear that that's what they mean is an adult, not a close relative, not related to the child, but nominated by the school or by the family or by an agent as someone who will care for the child for the full boarder during periods when they're not in the school. So they exeats, half terms, full term holidays potentially. A full boarder could also be cared for by a private foster carer or a close relative, but we're carrying over those definitions that we've already talked about as far as private foster carers and close relatives are concerned. So a close relative is only going to apply to a full boarder where they happen to have a close relative in the UK who is British or settled and over the age of 18 and able to care for them. And we don't think that a private foster carer would be possible because that child is never going to live with that person for more than 28 days. Certainly that would never be the intention. Weekly and flexi boarders can't be looked after by a nominated guardian. They can only be cared for when they're not in the school by a private foster carer or a close relative. We don't think a private foster carer could be appointed for a weekly boarder, maybe for a flexi boarder if the arrangement is so flexible that they will stay with them for 28 days. But a weekly boarder, unless they're sort of planning to spend summer holidays in the UK, for example, it's unlikely that a private foster carer would be appointable. So we'll come on to the problems with these rules, but one of them is to sort of give away some of my later points, is we don't see really practically how flexi and weekly boarding can work under these new rules. In each case, be they a nominated guardian for a full boarder or a private foster carer, asterisk, we don't think that's quite possible, or close relative, double asterisk, only in very rare cases, for flexi and weekly boarders and indeed for full boarders, they need to be British or settled and over the age of 18. Just say a bit more about nominated guardians. There's a definition within the immigration rules of what a nominated guardian is. So they must be over the age of 18. They will be appointed by the child's parent or their legal guardian or by the school as the child's carer while they're in the UK outside of term time for less than 28 days, or will be the school's emergency contact in the UK for the child's student. So even if the parents say to you, we don't intend for our child to ever live with this person who you're telling us we have to appoint, so why do we have to appoint someone? We will come and collect them from school at the end of term and take them back home. They won't stay in the UK unless they're staying at the school. It's quite clear that the intention is that the nominated guardian still needs to be appointed. Well, it's required that the nominated guardian still needs to be appointed, and the reason for that is within this definition, it's the school's emergency contact in the UK for that child student. The rule also makes it quite clear that the nominated guardian can't be a private foster carer, can't be a close relative, and also can't be the child's parent who holds a parent of a child student visa. So, that's fairly clear. The intended carer, be they a nominated guardian, a private foster carer, or close relative, has to provide a letter of undertaking. So we've now got this requirement for those of you who only ever sponsor boarders. You won't have ever come across a letter of undertaking before, but now this is something that you will need to ensure that is submitted with the visa application, because it is required by the nominated guardian or the other carer for your boarding pupil in the UK. That letter of undertaking, the immigration rules set out what information that letter of undertaking needs to have within it. It needs to say where and by whom the child will be cared for, confirmation that the accommodation provided is a private address and not a commercial enterprise like a hotel or a youth hostel. You have to set out the nature of the relationship between the child's parents and their intended carer. The letter also needs to provide a list of any other people that the carer supports or has offered support to, and details of anyone else regularly living with that person. So you remember I said that under the new care arrangement, care requirement rules, the decision maker can refuse if either the carer or anyone living with them has a criminal conviction. Well, that's how they find out whether that's the case or not, because those people will be identified in that letter of undertaking, and that allows the decision maker, UKVI, to do background checks on those people and see whether they have been convicted of any offences. Either the letter of undertaking or the parental consent letter, which you will have been requiring, which students would have been required to produce in any event for any child under the age of 18 applying for their visa, will have had to have submitted a parental consent letter with their visa application, before now anyway. But either the parental consent letter or the letter of undertaking need to set out what the child's care arrangements will be, and specify in particular they fall within one of these new prescribed care arrangements. So here's a summary. I hope I did sort of think about a slide in which I expanded my 5 boxes to show you all of the different new care arrangements. But actually, I think this table is perhaps a little bit more helpful, because it shows you under what arrangements are permissible for each different type of pupil that your schools might sponsor. I should apologise for anyone who's colourblind. I don't think the contrasting on this slide works terribly well, but if a box looks blank to you, it's because there's a green tick in it. And I've got to apologise. Hopefully that becomes clearer when you get the slides after this session. So if we're sponsoring day pupils, then those are the arrangements we've talked about previously. Obviously, they won't be living in the boarding house, but they could be cared for by a private foster carer or a close relative, or a parent with a parent of a child student visa, or they may live independently, but only if they're aged over 16. Full boarders will be cared for in the boarding house, obviously, during term time, and then otherwise could be looked after by a private foster carer, a close relative, or a nominated guardian. Weekly or flexi boarders obviously will be cared for by the school, but also could be cared for by a private foster carer or a close relative, and that's it under the rules as they're currently framed, and without any further clarification from UKVI, as much as I've begged for it. Just to say a few words about educational guardians. These are some sort of notes from colleagues who sort of specialise in this particular area. I've just pulled these together because I thought they were quite useful. Worth flagging that an educational guardian might be either an individual or a corporate entity, would generally be appointed by parents, even though the rules refer to them being appointed by the school. It's somebody who would be given delegated parental responsibility to care for a pupil while they're in the UK, and they'll do a variety of things, including arranging travel, transfer, welfare support, accommodation, where it's an educational guardianship agency, as a corporate entity who is the nominated guardian. They would arrange accommodation through what would normally be a vetted homestay. They will liaise with the school. They will carry insurance, that sort of thing. And so why do we have them? Well, from the 29th of May, we will have them because it's mandatory. for full boarders, but before now, they would have been appointed because they act as this very useful bridge between home and school. They're available in emergencies. They can speak up for the child in the absence of the parents being in the UK, or maybe where there's a language barrier or language issues, and so on. So lots of useful roles conducted by educational guardians. I realise now, looking at this slide, that the image I've used probably isn't terribly appropriate. I don't think too many educational guardians would be that close to the children they're looking after. Anyway, ignore that. Focus on the text. And worth also flagging that there is reference within the various sort of rules and guidance that schools have to follow as boarding schools, to educational guardians, which have been introduced relatively recently. So the national minimum standards for boarding now has standard 22, which refers specifically to guardians. Various points. I don't think I'll sort of labour the points too much on those, but just some useful points there if guardianship arrangements aren't something you're particularly familiar with. So, what are the problems with the new rules? Well, they are many, and I've tried to sort of summarise my main concerns, and these are the questions which we've asked of UKBI some weeks ago now, but are still waiting. And we've been promised further guidance, and I was really hoping that I would have that before today, so I could talk to you with some good news about what's been clarified, but I cannot. So these remain our sort of concerns. I've already mentioned the point in the concern about private foster care arrangements not arising for boarders because the child won't be living with them for 28 days. On the sort of practical point, you might still, where a parent is begging you to accept their child as a weekly or a flexi boarder and says, we will do anything, we will appoint a private foster carer. My fear is that even if you ask the local authority to assess somebody who the parents have identified as a private foster carer, they're not going to want to do it because they're going to see that the statutory statutory definition hasn't been met. And local authorities with stretched budgets are not normally in the habit of expending their resources on things where they don't need to. But there's going to be something of a postcode lottery there. Some local authorities might be prepared to do it, whereas I suspect many will not. So if we can't have a nominated guardian being appointed for a weekly or a flexi boarder, and private fostering doesn't arise, or the local authority refuse to recognise a care arrangement as private fostering, and the family don't have a close relative in the UK who is a British citizen or settled, then I don't see how we can offer weekly or flexi boarding under these rules. You can explore the opportunity. The only thing you can do under the rules as they're currently formulated is to see if you can persuade the local authority to appoint to recognise a private foster carer who the family have found to look after their child during weekends or on that flexi basis. Otherwise, it's full boarding or day arrangements only. The new rules do not appear to understand or recognise or even be aware of the concept of educational guardianship agencies, because as you'll have seen from the slide where I talked about what's required in the letter of undertaking, when you submit the visa application, in the letter of undertaking, you're supposed to say specifically who the child will be cared for by. Okay, fine, that could be a person at an educational guardianship agency, but you also need to say where they will be living and who else lives there. And my understanding is, as far as educational guardianship arrangements are concerned through an agency, quite often the homestay won't be arranged until quite soon before the child arrives in the UK. So normally after the visa has been approved, because the guardianship agency will take time to get to know the family, get to know the child, and find a suitable, properly vetted homestay for that child that's going to last. If we require the educational guardianship agency to appoint a homestay, as soon as the offer has been made by the school, then we risk situations where an inappropriate homestay arrangement is made that doesn't stick. The child arrives in the UK, hates the homestay family they've been placed with, and then we have to go to rigmarole finding them someone else. If the child's not so homesick that they decide they want to go home permanently. So there's a real issue there, but the only way around it at the moment seems to be for the educational guardianship agency to appoint the homestay immediately, specify that in the letter of undertaking, so that the letter of undertaking, sort of compliant letter of undertaking, can be submitted with the visa application. It would seem that under the new rules, a boarder cannot stay with a parent who holds a parent of a child student visa during exeats, half-term holidays. So the family, so a parent and several of the children are in the UK. Some of the children are under the age of 12. The parent's got a parent of a child student visa because those children are attending an independent school as day pupils. That's all quite legitimate. It would seem on the face of these new rules that your boarding pupil who's over the age of 12 can't go and stay with that parent during exeats and half terms. They have to stay with either a nominated guardian, not a relative, not their parent as defined, or a private foster carer or a close relative who isn't their nominated guardian or cannot be a nominated guardian. Anyway, yes, so that seems to be a bit of a gap in the rules. Similarly, the definitions of boarders don't make any reference, and their approved care arrangements don't make any reference to 16-year-olds who are permitted to live independently. And that leads me to wonder whether we don't call any 16-year-olds who are being sponsored boarders, even if they are living in a boarding house. Instead, we just call them someone who's living independently with their parents' consent. And it just so happens that their parents are consenting to living in the boarding house. It's a bit, it doesn't really make any sense, because otherwise that 16-year-old under the rules is supposed to live with a private foster carer or a close relative, or if they're a full boarder, a nominated guardian. But they can't live with a private foster carer because they're over 16 and private foster caring regulations don't apply to over 16s. They might not have a close relative in the UK. And so the only option then might be to either have them live with a nominated guardian or say that they are living independently. We've also asked the Home Office for clarification as to why boarders can't stay with a family friend who's, for example, in the UK on a 5-year skilled worker visa. We've also asked about parents visiting the UK or maybe come into the UK to stay with their child while they transition into boarding, or indeed maybe a parent who will come in every holiday and will care for the child then. It would seem that under the new rules that is not permitted. So lots of questions. As it says on the side, we've asked UKVI, not just me. It's not just me saying, "Dear Home Office, I'm Tom, please tell me some answers." We've done this through an association of immigration lawyers that I'm a member of, and we held a conference not long after these new rules came into force. We had someone from UKVI there. She promised to take our questions and to come back to us with further guidance on from her policy colleagues. That's what we're waiting for. So, how to stay compliant? Some practical tips. The new rules apply to all visa applications submitted on or after the 29th of May. So if you can get families to submit their visa applications before the 29th of May, that means those new rules don't apply. So that's one thing to bear in mind. Do note, though, that it's the date the visa application is submitted, not when you've assigned the CAS. It's the date when the visa application is submitted. And because you don't really have any control over when the parents submit the visa application, the sort of defensive position, the best practice position really is to say that the pupils, the new requirements have to be complied with now, because it might be that the visa application is submitted on or after the 29th of May. But if you're able to sort of insist on those families submitting their applications before the 29th of May, then at the very least, they won't have to comply with those new rules. The concern is, of course, that the requirement in the sponsor guidance for living arrangements to always comply with the requirements of the rules means that there'll be some sort of form of retroactivity in the new rules. Having said that, at the conference I mentioned a few months ago, the head of study services who was there and was speaking to us said that she didn't think that would be applied to visas issued before 29th of May, or certainly at least for students already in schools. But we need clarification on that, and we don't yet have it. You should be making sure that full boarders have appointed an educational guardian. And I would say that, you know, even before these new rules came into force as a best practice point, but now it is, now it's mandatory. Think about what due diligence you need to be doing on those educational guardians, and the homestays or that are being arranged for your boarding pupils. If it's an accredited agency, then that might satisfy you. I mean, there's no guidance on this. We're sort of making this up as we go along, but some sort of practical points on that. If it's an accredited guardianship agency, then that will act as a certain sort of level of due diligence. You might want to ask the agency where they're arranging homestays, what due diligence they're then doing on the homestays that are being arranged. You might ask the educational guardian, if they're a private individual, to confirm that they meet all those various requirements that are required to be in place for educational guardians. So being over the age of 18, not having any criminal convictions, nobody in their household having any criminal convictions, their immigration status, and so on. So do think about what level of due diligence you need to do. I think it will probably vary between situations where the family have appointed their own educational guardian as a private individual, and those where they've appointed someone through an agency, which will have its own sort of level of reassurance. Create your own template letter of undertaking. Look at what the new immigration rules say, and have a template that you can give to families so that they can make sure that letter of undertaking is drafted in accordance with the new rules and contains all of the information which is required. Weekly flexi boarders without a close relative in the UK can try to arrange a private foster care, as I've already said, but if the local authority isn't prepared to get involved, then that child needs to become a full boarder. There's not really any way around that under the new rules as they're currently formulated. I've already mentioned developing your own template parental consent letters, and you know, from a sort of practical point of view as well, I would say, you know, don't assign CASs until you're 100% sure, particularly where they're applying after the 28th of May, so on the day when the new rules come into force, until you're sure that they've got the required care arrangements in place. The CAS is the device you can use to force them to comply if they're being difficult with you. Just to sort of, I see there's loads of questions coming. I'm going to deal with those, and I can see we're very nearly at time. I'm happy to run over. I'm sure some of you have other meetings to go to. I will try and get to as many of the questions I can after 11 o'clock. I do apologise for running over, but as you can see, there's been a lot to get through. Just to say, if you're a school that needs support with its compliance with child student visas, there is a product out there which has been designed specifically for schools to help with that compliance. You know, full cards on the table. Full disclosure, I've had some input into that. It's developed by ITQ Metis. It's a software platform accessible by the schools and by the families and agents as well, and helps with the workflow of conducting due diligence on the families, making sure that you've got all the relevant documents and assurances in place before you assign the CAS, and then provides guidance for the families / agents through the visa application process. I won't labour that point, but if anybody is interested, let us know, and we can pass your details on to ITQ Metis on that. Final sort of substantive stuff just to talk about relates to the new sponsorship duty, which we've been told will be introduced from the 29th of May in relation to travel arrangements. Got a very mature looking student on the slide, but the Home Office have said that this new duty will be introduced where child student sponsors will be required to make reasonable endeavours to collect information on travel arrangements for students with a nominated guardian. So full boarders with a nominated guardian or educational guardian, to use our language. Sponsors will have to keep records of when the child is arriving, record details of the person collecting the child, record where the child will be staying if they're not proceeding directly to the school, and report to the relevant authority if the child does not enroll at the school. You need to use your reasonable, keep a record of your reasonable attempts to collect that information if you haven't been able to collect it all. So that's a new duty. Do have a think about how you're going to comply with that. I suspect that's something that's going to rest with the boarding houses, isn't it? To make sure that they're collecting that information. So make sure you've got arrangements in place to collect that information. If you don't already, I suspect probably quite a lot of you, do. Right, there's a poll that's going to come up on screen. If you need any additional support, do let us know. I'm going to look through your Q&As, of which there have been loads. So as I said, let's just plow through as many of these as we can, and we will ignore the fact that I've run over time. You can all forgive me, please. So, first question. This came in at 10:05, but even so, let's go through. So, when parents are in the UK as a visitor, can a sponsored full boarder stay at weekends with the parent? If so, if the parent is a visitor for 6 months, can this child become a weekly boarder? Well, not according to the new rules, no. Full boarder doesn't stay with anybody at the weekends. They stay at the school at weekends, apart from an exeat or half term. We have asked, within our list of questions to UKVI, one of the questions we have asked is whether a quite typical situation I've been asked about on many occasions, where the child's a bit younger and so nervous about going into full boarding. So a parent comes over for a few months, and over the course of a couple of months or so, the child sort of gradually integrates themselves into the boarding house. So maybe they do a night or two a week to begin with, and then over the course of a few weeks, they become a full boarder. We've asked whether that would be okay. On the face of the rules, it is not. It seems that the only people who can care for them are the school, or a nominated guardian, or a private foster carer, or a close relative. Close relative does not include parent. So on the face of the new rules, the answer to that question, excuse me, is no, but we hope for clarification. But at this stage, I would suggest that you prepare for the fact that it won't be permissible. We have a Singaporean full boarder. His parents have appointed a guardian who is resident in the UK. However, exeat, he stayed with a family friend for the weekend. What consent do we need for this arrangement? Well, again, strictly on the rules, it's arguable or even fairly clear that that isn't permitted. But again, we've asked a question about this of UKVI. We hope that we're going to get something in a FAQs document. Yeah, we hope for some further clarification. I would say that, just from a practical point of view, it's quite, you need to have the consent from the parents, or if they've got a guardian in the UK, and the parents aren't reachable, or the parents have delegated parental responsibility for the child while they're in the UK to that guardian, the guardian could consent. But I'm still nervous, based on what the new rules say, that we can't have children doing those nice things because they need to live with either the school or a nominated guardian or a private foster carer or a close relative. Stop me if this gets tedious. I assume if students apply before the new rule changes come in on 29th of May, that the existing rules apply. I'm trying to encourage schools to apply, students to apply early. Yes, do. Certainly, they won't have to produce a letter of undertaking in, where they're a full boarder. They wouldn't have to produce a letter of undertaking in the form prescribed by the new rules. I just have that niggling concern that there's going to be something which says, for existing pupils, you need to ensure that they have a nominated guardian, and that guardian needs to be British or settled, and so on. Okay, would students aged 16 or 17 living in homestay arranged by the school be considered boarding students, or 16, 17 living independently? Well, yes, I've asked that question myself, and I don't know the answer. I mean, if they're boarding, they're boarders, right? So we would call them a boarder. I mean, why would you call them something else? Except the new rules seem to be pushing us down the pathway where we say, well, for practical purposes, and so that we don't get lots of scrutiny and we can ensure that we comply with the requirements of the rules, we'll call them living independently. Again, we've asked that question of UKVI, and we are waiting for clarification. Where does weekly boarding sit in the permitted living arrangements? I wonder if that question came in before I started talking about what the new permitted living arrangements are. Weekly boarding is classed the same as flexi boarding. It is different from full boarding, and a weekly or a flexi boarder can only be cared for by a private foster carer, but good luck getting one of those recognised, or a close relative, but only if that close relative is a British citizen or settled, and we don't know. Well, in most cases, most families won't have someone in that situation who's able to do that. Okay. Can a weekly boarder reside at a weekend holidays with a parent who holds a parent of a child student visa linked to a younger sibling? Does this meet the living arrangements? No, not according to the new rules. No, but maybe we'll get some clarification on that. If a pupil of 16 years who's not British wishes to apply for independent living arrangement with parental consent, could they live with a British citizen who moves long-term to the UK? Oh, with a British parent, sorry, who moves long-term to the UK. Yes, if they're 16, yes. We call them a day pupil living independently, and that would be that. We have had a guardian form sent in today with the guardian here on status graduate route. Within the summary of what they can do in the UK, it says can live in the UK until February 2027. If he's over 25, can this person be a guardian? Not under the new rules, no. That person is not settled. Settled means indefinite leave to remain. If you looked at their e-visa, if they give you a share code, you look at their e-visa, it will say they have no time restrictions on their permission to live in the UK. So no, that person under the new rules cannot be a nominated guardian. Okay, hi, do these rules apply for children already in the school and sponsored? What about for non-sponsored pupils? Okay, so taking the second point first, non-sponsored pupils, no, these rules don't apply. They are an international student but have another form of immigration status. So maybe the whole family are here and the child is on a dependent visa, or maybe the child is a British citizen in their own right, but the parents aren't here, but that's fine. They're British, so they're entitled to be here and study. They don't fall within the new regime at all, and so we don't have to worry about what their child arrangements are, other than your usual sort of safeguarding duties towards that particular child. Do they apply for children already in the school and sponsored? That's the bit we don't know. Well, there's an argument that they will because of the way that bit of guidance I flagged up, which says that you need to ensure that living arrangements comply with the requirements of the immigration rules. But we've been told verbally that it's unlikely that there will be, or it doesn't seem reasonable to sort of imply those standards on students who are already here, but we haven't had that assurance in writing. So it would probably be sensible to do some sort of exercise to sort of think about your current pupils and what they're, whether they've got educational guardians and who those educational guardians are, whether they meet the new requirements. Will child students need to have a nominated guardian for all living categories, including private fostering and 16, 17 living independently, or just boarding students? No. If you're a day pupil, then your carer is either the private foster carer or the close relative or the parent on the parent of a child student visa. 16 and 17-year-olds living independently are permitted to do just that. So you don't need to nominate an educational guardian. But lots of schools do, and that's to comply with the duty to ensure that the care arrangements in place for a child are suitable. And if we're just, if we've got a child living in a flat on their own, not having anybody in the UK who can look after them or to look out for them, probably isn't suitable. So that's, I think, how that would be considered. Do we need to see the letter of undertaking as long as we've told parents it must be sent with their visa application? I think at least initially, I would be asking to see them to make sure that parents are doing them, or at the very least, provide them with a template which sets out all of the information they need to have in it. You don't need, there's nothing that we're aware of. Certainly, there's nothing in the rules now or in the guidance now which says you need to see or have that letter of undertaking on your files. Not in the same way. The parental consent letter is a mandatory document. You must have it. So we should see that, and it's probably a good idea to get that before we assign the CAS to make sure that we get it. But the letter of undertaking doesn't, as far as we know, isn't currently a record-keeping duty, but it may be introduced as one. And if they don't put in the letter of undertaking, then the visa application is going to be refused, and we don't want that. So maybe it's not a bad idea to see the letter of undertaking. How does a homestay guardian appointed through an accredited agency to meet the requirement of not being a commercial enterprise? They're being paid to use their home as a place to stay for sponsor pupils. It's a good question, except that I think that the examples it gives as commercial enterprises are youth hostels and hotels. So, the home isn't primarily being used as a commercial enterprise. I think that's the way that we would interpret that. But that may be something to ask your guardianship agency, because they may be able to speak to that better than I can. We're a full boarding school with exeats every 2 weeks, but have parents of a child student visa holding parents, which contradicts your table. Do you have any more information on that? Well, it contradicts my table because under the current rules, full boarders can stay with anybody. But as of 29th of May, they can't. They can only stay with a nominated guardian or a close relative who holds a British citizenship or settled status, or a private foster carer. So from the 29th of May, my table is correct. My table is not describing the situation as it is now. Sorry, that sounds a bit offensive. Okay, are DBS certificates a requirement? And if they are, who is responsible for arranging them? Nothing in the rules to say that you need to do DBS checks on anybody. But this comes to my point I was making about due diligence on private foster, on educational guardians. I would, so, and if the parents are appointing a guardian through an agency or appointing an agency, and that agency is accredited, and you don't have any qualms about working with them, then you can probably rely on the agency to do its own vetting on the homestays that are being arranged, and make certain assumptions that they're accredited through Aegis or the BSA scheme or whatever, that the agent has been accredited. Then you can probably, not have to worry about doing those checks yourself. If the parents are arranging their own educational guardian, and that's a private individual, then I would say that at the very least, you probably need to be asking them questions as to whether they or anybody living with them have any criminal convictions, and making sure that the person nominated is British or settled. Do you need to do DBS checks on those nominated guardians? Nothing in the rules or the current guidance says you do, but you may want to start thinking about it. But I can't tell you that you must, because it's not mandatory as things stand. If that changes and they do say it's mandatory, I will certainly be putting out articles and maybe even run another webinar. But as things stand, yeah, that's the position. It's not mandatory, but I would say that as best practice, you should be doing some level of due diligence. And in some cases, you might decide that involves a DBS check. Your point about timing is very relevant. Well, that's very kind of you to say so. This is my biggest concern. Currently, guardians are appointed after the visa application is submitted in most cases. It seems absurd to put these arrangements in place so early. Also, do we need to be DBS checking guardians? I've just answered that point. So obviously slow down visa processes more generally. Should we be checking all guardian visas, passports? I couldn't agree more. Yeah, it does seem crazy, but I'm afraid that is what the new rules require. You know, if you can get the applications before the 29th of May, then you can avoid it. After that, it's required. And certainly as far as, you know, recruitment / admissions for September 2026 is concerned, they're going to need to have nominated a guardian before the visa application is submitted. It's as simple as that. What was the other point within that? Oh, DBS checks, yeah, we've already addressed. Should we be checking all guardian visas, passports? Again, I think this comes to the due diligence point. Probably you don't need to with an accredited agency, but maybe you would think about that for a privately appointed guardian. Our Spanish full boarders stay with their visiting parents in London for exeat. Is this permitted? Not under the new rules, no. Can you comment on child student visa extensions? Will this apply to anyone extending? Yes, it will apply to extension applications. It applies equally to extension applications and to new visa applications. Is the letter of undertaking in addition to parental consent for application, travel, etc.? Yes, it is. So there's two documents they'll need to submit: the letter of undertaking and the parental consent letter. In terms of travel arrangements, do schools need to ensure they see pupils to the security gate at airports? No. Well, again, there's no explicit guidance on that point. I think you would do each on a sort of risk-based assessment. So if you had very young boarders, for example, then you probably would want to sort of take more care to ensure they safely get on their flight. For older pupils, you probably don't need to do that, but you, as best practice, would probably have some sort of process for verifying that they've got on the flights or that they have contacts for people if there are any problems. So again, this is one of those where there's a sort of range of responses and range of things that we're told compliance officers talk about during inspections that appear to sort of be more restrictive or more onerous than the guidance actually requires. I think this is one of those where you sort of need to take a risk-based approach based on your pupils and the circumstances of your school. Can a full boarder stay overnight with school friends at a weekend? Well, it appears not. I mean, that just seems crazy, doesn't it? Again, this is one of the things we've asked UKVI. Hopefully we'll get some clarification on that. Do we as a sponsor need to gather evidence regarding parental visas after CAS has been issued as part of record keeping for existing CAS students on a day student non-boarder? We as a sponsor need to gather evidence regarding parental visas after CAS has been issued? Oh, so I suppose if we've got a parent of a child student visa holder, is that what we're saying? I mean, I think it's probably a good idea. There's no record keeping duty to get that, but yes, I think it'd probably be good to know when the parent's visa expires, because apart from anything else, as a day school, you need to make sure, as a day pupil, you need to ensure that there's an approved living arrangement that child can go into when the parent's visa expires. Do educational guardians need DBS? I think I've already answered that. How often should checks on care arrangements be carried out? Or should there be an onus on the sponsor to ensure compliance of parents' visas annually, the record keeping duty? It's not a record keeping duty, but I think you probably need to sort of build in some process for verifying that the care arrangements that are in place are still in place. And sometimes that will be quite apparent, that will sort of come to light. So I suppose the staff at the school who come into contact with pupils and the parents and their guardians regularly need to be aware of the sponsored pupils and to flag with the relevant people in the compliance team at the school where they think that a change has arisen. But there's no sort of mandated standard for sort of going out and carrying out change. I mean, but you could think about, if you don't think it will come to light, naturally, do you maybe go out once a term and say, can you just confirm what the care arrangements are, something like that. But that's essentially for you to assess. There's nothing in the guidance that tells us the answer to that. Do we know how the SMS is going to change to take into account these new rules? We don't. We wonder if maybe they will ask you to specify that they will be a weekly flexi, full border, day arrangements, whatever, but we don't know just yet. Okay, nearly there. Can weekly and full boarders stay with parents who hold a British passport or have settled status at weekends, exeat, or holidays? I've definitely answered that one before. I mean, the answer if they're a sponsored pupil, the answer is no. If the student hold a child student visa, the answer is no. One of your cited that no staff member should be a nominated guardian under any circumstances, I believe. Can you just confirm that? Yeah, that's not my area, but that's my understanding. That comes from the national minimum standards and the standard 22, I think it is, on educational guardians. I'm pretty sure that's in there, saying that members of staff shouldn't be educational guardians. But speak to your safeguarding colleagues about that, because that's a national minimum standards thing. Can I clarify that essentially a child cannot stay with their parent if they're on any form of visa? I think that's pretty much what it boils down to. Yes. Just confirmed, the Spanish children have to stay. Okay, another question about Spanish children. Stay with their guardian for exeats. This will be very harsh for families to travel to and from London to see their children at exeats. That's what the rules say. I don't know how many other ways I can say it. That's what the rules say. The rules say they have to stay with their nominated guardian or a close relative who's British or a private foster carer. The school's required to do homestay checks for educational guardians that are not part of an accredited agency. This, I suppose, will come down to the level of due diligence that you think is necessary in that particular case. You might feel that you need to. I mean, I think maybe not a bad idea for the boarding staff to be speaking to them at the very least, trying to get to know them, that sort of thing. But look, there's no mandated guidance on that, but you do need to make sure that the arrangements are suitable. So you probably need to do something, don't you? Can the school take students on overnight residential trips in or out of term time if the school remains the responsible body for the student? I mean, that has to be a yes, doesn't it? Yeah, if they're in the school's care, so that's got to be fine. Can a child stay with a family friend as the educational guardian, providing they're British or settled? I mean, yes, if the family friend is British or settled, then they can be a nominated guardian for a full boarder. Yeah, they would be appointed as the educational guardian, as a nominated guardian. That then goes back to those questions about what sort of due diligence you do. But yes, that's absolutely fine. Can you please share the wording guidance that relates to appointing educational guardians being mandatory? It's in the immigration rules. So if you Google UKVI immigration rules, you're looking for the statement of changes to the immigration rules. It's also in the article I put out a few weeks ago. So if you go on our website, you can find it there. But yeah, educational guardians are now mandatory from the 29th of May for boarders. Done. That is your Q's and my A's. We've run well over. I do apologise. I do hope that's been useful. Here's a feedback poll. If anybody says below average after I've just done an hour and 22 minutes, I'm going to be a little bit upset. Someone's going to do it now just to spite me. but I'm thirsty for praise, as well as some water, actually. So thank you very much for attending. I do hope, oh, it's a one final, yes, look, there's my contact details. Do feel free to get in touch. If you have any further questions, if there's anything we can help with, please let us know. Please enjoy the rest of your days. Thank you very much for attending.